Hi, everybody. We're coming to you live from the Kill Room at Lois LLC. And this is the latest episode of the Third Fridays podcast. My name is Christian Cison, and I want to thank everybody for continuing to come back. Last episode, we talked about cross-state jurisdictional issues with trying to bring it back with New York and New Jersey, but obviously it has various outlays that it could be stretched to. Today we're going to talk a little bit about contractors, staffing agencies, and waivers. It's going to get a little nerdy up in here, so please do not turn off the podcast. Today's guest is a good friend of mine. His name is Chris Major, and I welcome him to the program. How are you doing today, Chris?
How's it going, Christian? Thanks for having me.
All right, so what we're going to do today is talk about a case that is going to come before the New Jersey Supreme Court. So, Chris, why don't you give us a little background and get us started?
Right. So the case here is, I hope I'm pronouncing this correctly, Vitale versus, I'm going to say that's Shearing Plow Corporation. The way I sort of got implicated in discussing this case is I'm Lois Law Firm's Section 40 reimbursement guy. And
well, you're more than that to us, Chris. Come on.
well, that's allegedly my primary role. And so the case makes a very sort of tertiary glancing mention of Section 40, and suddenly it ended up in my lap as a result, but we'll get to that. So I just wanted to, as with any case, we'll start with just a brief recitation of the facts in this one. Basically, the plaintiff, Philip Vitale, who we'll just call the plaintiff from here on out, was a security guard employed by Allied Barton Security Services, LLC. We'll just call them Allied. Allied contracted to provide security services at defendant Shearing Plow Corporation, who we'll just call defendant. And at the commencement of the plaintiff's employment, and as a condition to it, he was required to execute a disclaimer waiving his right to sue any of Allied's customers for, quote-unquote, injuries which are covered under the workers' compensation statutes. While he was working at one of the defendant's facilities, he tripped over bag of salt on the stairwell and sustained injury. He then filed a personal injury suit against the defendant, contrary to the waiver he had executed with his employer. He had received workers' compensation benefits from Allied Barton. At trial, the jury found that defendant's negligence caused the plaintiff's injuries, gave him $900,000 in damages.
Yikes, $900K, huh?
Yeah, which is definitely more than he was probably going to get just under strict workers' comp.
And it's absolutely more than he probably deserved.
So, basically, the defendant moved for summary judgment on the basis that the disclaimer was valid and enforceable, and they lost on that motion. They appealed that decision. So I think the best place to begin with the analysis of what went on in this case is to look at the language of the waiver itself. And I'm just going to cite the pertinent portion of the disclaimer. As a result, and in consideration of Allied offering me employment, I hereby waive and forever release any and all rights I may have to make a claim or commence a lawsuit or recover damages or losses from or against any customer and the employees of any customer of Allied Security to which I may be assigned arising from or related to injuries, and this I thought was important, which are covered under the workers' compensation statutes.
Okay, so let's stop there. Let's back up the legal jargon and make it understandable to everybody here, right? We have Allied, and they are typically, during the course of their business, going to make contracts with third-party entities, right?
Right.
And Allied is going to have employees that are going to be involved in the carrying out of services of those contracts with the third-party entities.
Yes, and something Christian and I are going to get into a little later is there's actually a different issue going on here, which is the context of temp agencies and hiring companies and workers' compensation in that realm, but we'll get to that.
Okay, so we have the waiver, right? And we have a situation where obviously the petitioner or the plaintiff in this case is kind of foregoing that waiver, right? Because he's filing suit against the customer or someone involved with the customer, right?
Right.
Okay. Now, the summary judgment motion brought forth by the defendants was not granted.
Yes.
And it went before the appellate division in New Jersey. What did that court find?
So ultimately, through typically very long and flowery legal jargon, they arrive at the point that it's violative against public policy, the waiver as it's written, and as it operates. So there's a number of reasons how they get there. One thing that I thought was interesting is that they mentioned this waiver of the right to sue under Section 40. Section 40 involves actions against third parties. Perfect example, car accident, just a person outside of work. The person driving obviously gets workers' compensation, like they're a FedEx delivery driver or something. In addition to getting workers' comp for getting hurt while on the job while driving, there's obviously just your usual motor vehicle negligence suit that accompanies that. So Section 40 gives the workers' compensation carrier or respondent, however you want to phrase it, a right to reimbursement against anything that the worker recovers in a third-party civil suit. So what's interesting is that they mention that this waiver of the right to sue under Section 40 is violative against public policy, but then they don't go into Section 40 at all. That discussion is not particularly fleshed out here. So they talk about the waiver language. They say that the fact that it's a condition of employment signing this waiver makes it a sort of contract of adhesion, which basically stems from the concept that, these parties are in disparate bargaining positions.
Right. I believe the law school explanation of that is the take it or leave it kind of contract, which in and of itself is a debate, right? I mean, you have two parties who are not forced to enter into the contract, yet contracts of adhesion are not looked upon as favorable by any court, really.
Right, and I actually, not to get too far down this road, I actually kind of take issue with that.
Let's get on the soapbox, Chris. Let's do it.
I mean, it's at some point you're just infringing on people's freedom of contract. I mean, they're entering into it knowingly. They're entering into it for a reason, and the court actually does sort of touch on that, where they say that, even though this is a contract of adhesion, he was entitled to reject this and seek other employment, but they declined to go down this road of discussing the contract of adhesion because, interestingly, the plaintiff does not allege unconscionability in the contract formation. He's alleging that it's unconscionable in the way it operates. So he's not saying that, this contract of adhesion topic is making his very signing of the waiver unenforceable. He's saying that the waiver is unenforceable because of what it does to his right to sue. So, the court goes into a discussion about how exculpatory clauses are disfavored because they encourage a certain lack of care on part of the party that, they purport to remove liability from. They can be enforceable if they're not against public policy. And the plaintiff raises public policy concerns.
Well, he has to, right? Because if it's not against public policy, then he's kind of stuck with the terms of the contract.
Which, as I just got up on my soapbox about, he knowingly and willingly entered into. So, I mean, despite the disparate bargaining power. Right.
So he's got an out here, which he has to use in order to recover. And the appellate division finds that it's void against public policy, right?
Right. And the reasons they cite, the plaintiff raises two reasons. He says it's against public policy in the areas of premises liability and as against the, beneficent purposes of the Workers' Compensation Act. So, the court points out that there's no inherently risky behavior involved in what he's doing here. This is not an assumption of risk case. This is not one of those things where, you go on the ice to play hockey, you're pretty much accepting you're going to get body checked at some point. No, this is just a guy who's walking around property. So we're subject to regular premises liability here.
Right. Tell that to every employee that works for every other employer, right? Everything that they encounter in their job is an assumption of the risk of taking that job. But again, now I'm getting on my soapbox, but we have an appellate division ruling, and if it's void against public policy, the Supreme Court could have just let it stand, right? I mean, why even decide to hear this case at all if there is an option for them to just deny certification?
Yeah, and this was something you and I had actually discussed somewhat at length. It's interesting that they granted certification on this, right? Because you wouldn't think that public policy is sort of a hairy area in which to make law.
Right. Give a mouse a cookie, and then
he's going to ask for a glass of milk.
Right.
So, I mean, it's interesting that instead of just letting this stay confined to what the appellate division said, they're going to somehow rule on it, and we can speculate as to what they're going to rule on. But what you and I came up with, Christian, is that we think this issue of the temp agency to hiring company relationship in the world of workers' compensation is something that really hasn't been explored, and in fact is not even addressed by statute. And this is the topic that you mentioned at the outset of this podcast, which is the general contractor to subcontractor relationship and how that plays into workers' comp. And I think you said there's a specific application of that in New York.
Right. So it's important to a lot of our clients currently. This whole in New York you'll hear of general special being thrown around, and in New Jersey it would be the special employer doctrine. Is that what it's called?
Right, which is something distinct from the subcontractor to general contractor analysis. So there's actually the Workers' Compensation Act 34:15-79, which we'll just call Section 79. It specifically addresses the situation of a subcontractor to general contractor. And basically just, obviously I'm paraphrasing here, It says that when a subcontractor does not have workers' compensation insurance and their employee gets injured, the general contractor can be liable for workers' compensation coverage. And Section 79 just addresses that specific situation. And, we recently looked into this topic a little more internally. And we found that this is an area of the law that actually has not been addressed. So you have Section 79, which talks about this general and subcontractor relationship, but there's a number of different cases that just sort of narrow this definition.
See, I told you were more than just a Section 40 superhero.
Yeah, I also step in with legal research as needed. But, there's one that we have, I hope I'm pronouncing this correct, Brigadier versus Riemann. So they defined what contractor meant under Section 79. And it's Brigadier, the decision, stands for the essential proposition that the term contractor under 79 has the limited definition of one who contracts directly with the owner of property for construction or improvement or repair or work to be performed. So a subcontractor in Brigadier is basically someone who's undertaking to do work for which someone has already contracted to do work. They're stepping into the shoes, or the general contractor is farming out the work to somebody more qualified or more specialized to do it. Now, this is a distinct analysis from this special employer doctrine, which basically, and there's a test carved out through case law, basically if the test is met, the worker can be held to have two employers. And this is actually where we tie back into Vitale here. The Vitale decision actually has a pretty concise summation of this special employer doctrine, and they lay out the factors of it and the special employer, i.e. the second employer, or in the example we're talking about right now, the hiring company that's hiring from the temp agency, they're sort of the second employer in this instance, right? The test laid out is the special employer is liable for workers' compensation only if the employee has made a contract of hire, express or implied, with the special employer. The work being done is essentially that of the special employer. The special employer has the right to control the details of the work, and they discuss two additional factors that may also be considered, whether the special employer pays the employee's wages and whether the special employer has the power to hire, discharge, or recall the employee.
Right. So we talked about how it almost comes full circle, and that segue was so seamless, it was almost as if we didn't practice that, right?
Oh, no practice at all.
So what we have here is we're bringing it back to Vitaly because in trying to predict or figure out why the New Jersey Supreme Court would want to look at this case instead of letting the appellate division's opinion stand is this, I don't want to say, I guess, difference, but, well, yeah, the difference between contractor and temp agency, the relationship between those specific industries, and making a more clear delineation between them, maybe not an intention of the Supreme Court in doing it, but an unintended consequence of hearing this case may actually be to make Brigadier, Blessing, Briggs,
all those other cases.
Right. Just go down the line. Those cases that may not necessarily be binding on the difference between those industries, make them more persuasive, or maybe even make them binding, right? Actually having to comment on that, even dicta could make that delineation or the difference between those two industries stronger.
Right, and I think that's the collateral consequence the New Jersey Supreme Court runs the risk of touching on here in granting cert on Vitaly. Because here, on one hand, you have a type of coverage that, the New Jersey legislature has specifically contemplated, right? You have Section 79, which talks about subcontractor to general contractor. The special employer doctrine is not a recitation of something prescribed by statute. This is the court filling the gaps. This is a situation where you go, we have a temp agency, we have a hiring company. At the time when the injury happens, who's liable? Is it the person who's hiring the contractor to perform the work, or is it the person that's farming out the contractor to other companies? And so, in ruling on Vitaly, the New Jersey Supreme Court may actually offer us a little bit of clarification on this whole temp to hiring agency distinction versus the subcontractor to general contractor under Section 79.
And actually, while we wait for that, right, because it's not like it's coming down the pipeline tomorrow, what I like about this type of case is it actually forces us to get our hands dirty. We have to actually do the digging and figuring out what type of relationship clients have with their customers, what type of relationship is born out of that relationship that involves the petitioner or the claimant, and how those kind of react with each other to kind of form the basis of a defense. And I think, you talked about that test in New Jersey. New York started to go along with that test. More recently, they're focusing on who has the ability to direct and control that employee. It kind of makes it easier for the courts to make a decision on general special. But it's kind of this whole topic is actually something that we enjoy because we can actually go in there, really provide value in figuring out where the case stands before it goes to trial, as opposed to, your more commonplace accept or deny case based on whether the accident happened, right?
Right, and in the context of defending against, possibly meritless workers' compensation claims, this general or special employer doctrine could represent something of an all-or-nothing proposition in the sense that, if this hiring company is not a special employer under the test, well, I mean, in New Jersey, what the appellate division is seeming to say in Vitale and what they've carved out in other cases is that if you don't qualify as a special employer, you're not liable for compensation. And what's interesting is how the context of if the temp agency is uninsured, like Section 79 contemplates for subcontractors, then what happens? Then what happens if the hiring company does not qualify as a special employer or the temp agency just happens to lack insurance as contemplated by Section 79? But as we've established, Section 79 only addresses general and subcontractors very specifically in a very specific situation.
Okay. So a lot of information there to digest. So what we have now is Vitale coming up to the Supreme Court. If you had to guess, right, we usually play guess the outcome here. It's not really relevant to this particular episode, but I kind of want to make a game out of this because, sure, who loves games, right? Me. What is the Supreme Court going to say about Vitale?
So this is an interesting one. It's kind of tough to forecast, right? Because on the one hand, you have this sort of hairy issue of public policy, which, as we've seen before, state Supreme Courts are hesitant to dive into for obvious reasons of making law based on, this doesn't feel right, essentially. But on the other hand, if you're not going to rule on the entire public policy decision or discussion, which is basically the entire basis for the Vitale appellate division's decision, why are you granting cert? So it's interesting because I think they're going to take a cop-out and just sort of say, we agree that, you can't waive liability via these third-party waivers ahead of time as a condition of employment because you don't know what you're waiving. That's one discussion they go into is that, when the plaintiff is signing this waiver, it's protecting an as-yet unidentified third party, right? And in that sense, Allied's customers are third-party beneficiaries of this contract. And, they don't even exist yet. They're as-yet unknown. So first of all, the employee has no idea what they're waiving. They don't know the situation that could arise in the future. So there's the public policy concern there. Secondly, you can't waive under any circumstances, we're workers' compensation attorneys. Feel free to correct me if I'm wrong on this, Christian, but I don't believe you can contract around intentional or reckless conduct under any circumstances.
Right. I don't even think that's just a workers' comp thing.
Yeah. So, I mean, there's this issue that I actually found kind of interesting, but, as we've established, that's because I'm a nerd.
Me too. It's okay. Good company.
So they talk about how you can't waive liability for the intentional or reckless conduct. And, what the defendant seeks to argue is that since the waiver addresses claims covered by the workers' compensation, it specifically says any claims that would be covered by workers' compensation. And the Workers' Compensation Act in New Jersey excludes claims for intentional conduct. Well, then this waiver is in accordance with the Workers' Compensation Act. It's not permitting intentional reckless conduct and beyond what, the Workers' Compensation Act forbids. And the court struck down that argument, saying the definition of intentional and reckless conduct for purposes of the Workers' Compensation Act is way narrower. I mean, it's got to be this situation where I think the language they used is substantial certainty of bodily injury or death. I mean, it's essentially got to be an employer sending their employee to like a known death sentence. And so the context of tort, intentional and reckless conduct, as most of the world knows it, is broader. And if you can have a situation where this waiver claims to waive intentional and reckless conduct and waive stuff beyond the Workers' Compensation Act, even if it says, well, this only applies to injuries that would be covered by workers' compensation. So
you might even say in the wrong hands it encourages intentional and reckless conduct.
Oh, yeah. Or
we want to be really dramatic about it.
Well, it's funny that you say that because as the Vitale court repeatedly makes the point, these waivers encourage a quote-unquote certain lack of care, as if people are going to, start laying barbed wire on the floor in the dark for contractors on their property.
It's just a simple prank. Get over it, dude.
Yeah, we do that here all the time. So, to circle back to the question, which, again, I went off on another tangent, I do think they take the cop-out approach. I do think they say, we agree with the analysis. I mean, tort, intentional, and reckless conduct is broader than workers' comp, intentional, and reckless conduct. And you can't waive that, even if you try to tie it into the scope of workers' comp. And you can't, you can't waive injuries that aren't, you have no idea what they could be based on this whole premises liability argument. I think they say, we agree with this analysis. The reason, and again, I'm just speculating, that they may have granted cert is because, as you and I have established over the course of this podcast, this is a relatively unsettled area of law. There's a lot of collateral implications that can come from a New Jersey Supreme Court decision on this particular issue. And to that extent, and here comes the nerdiness again, I'm actually pretty excited to see where this leads.
There it is. I actually agree with you, and I want to add this caveat, right? Because if you're granting certification to hear a case that was determined based on a public policy argument, you can almost feel the decision coming down in a way to restrict it to that particular fact pattern, right? Think about extending that public policy argument to all different types of industries. That would create so much more litigation, which the courts certainly do not want. And I actually think about comparing a temp agency to a more sophisticated industry, right? Because if you're talking about a waiver being a contract or a term of adhesion, you can't really make that analysis when you have let's say a situation where parties contract for years and the employees continually waive this and they sign paperwork saying that I'm not going to do this consistently over and over again for the life of a long period of time. You can't then go back after years of doing so and say, oh, well, it's a contract of adhesion, right? It has to be restrictive to this particular fact pattern, and I think that's a big reason why certification was granted by the Supreme Court in this case.
Right, and I think that that's something that the Vitale Court touches on too, the defense in making their argument attempts to touch on is like, hey, these sort of waivers are standard practice in our industry. They're our competitive edge. Our clients or our customers expect this. And so, as you pointed out, any sort of decision on these on public policy as applied to these sort of waivers could have this ripple effect across more areas of law than just workers' compensation. Now, I will add, just as a small side note, selfishly, I hope they dive into the Section 40 issue more than the appellate division did, because I'm interested to hear the analysis on how Section 40 is implicated in this. Beyond the obvious, Section 40 permits, well, it doesn't actually permit third-party suits. It permits a lien in third-party suits. But, I mean, beyond just saying that, waiving the right to sue goes against Section 40, the court doesn't really dive into that. And I would be interested to see if that issue is mentioned at all.
Okay, so do you hear that, fellow Lois LLC employees? When you see Chris hovering over the next couple issues of the Law Journal, just let him be, right? Let him read and delve into this. He'll probably explain it to you in a really, really excited tone. So that's all the time we have today for this episode of Third Fridays. We don't have time to bring Greg Lois on. Sorry, bud. Maybe next month. But Chris, my Section 40 superhero and more, thank you for coming on.
Thank you so much for having me. This was fun.
I think we'll have to have a repeat episode once that Supreme Court decision comes out. But for Chris, this is Christian Cisan reminding you guys to defend from day one.